Imagine this, a multi-million dollar software contract, and the developer only finishes half the work. The rest, months late, maybe never delivered at all. So, should the client pay for the half they got? Or can they just claim a total breach and say the developer owes them money now? It's a high-stakes legal nightmare, really. And today, we're diving deep into how contract law answers that very question using two critical doctrines, divisibility and waiver.
Exactly. We're looking at contract performance from a structural perspective. And to really get this, you need to master the legal rule for what we call a divisible contract. What makes a single document act like a bunch of smaller contracts. And then we have to examine the doctrine of waiver. Waiver is often the silent killer of a perfectly good legal defense. It can punish the non-breaching party for their own actions. We'll model all of this through the case Scavenger, Inc. v. GT Interactive Software.
Okay, let's start with the money. If one party breaches part of a contract that has multiple items, can they still get paid for what they did deliver? What's the single deciding factor here?
The deciding factor is structure. It's all about the structure. The general rule, which you'll see in cases like Christian v. Christian, says that a contract is divisible only when the performance is split into two or more parts. And, this is the critical part, the consideration, the payment, is specifically and correspondingly apportioned for each of those parts. The entire analysis hinges on that. Finding a match between performance units and payment units. If you have that financial structure, then failing to perform one part doesn't stop you from getting paid for the parts you did complete.
So it's not just about delivering multiple things. The contract has to be written almost like a detailed menu, with a separate price next to each item. We're going to test this rule now with the Scavenger case. So Scavenger was hired to develop and deliver 4 CD-ROM games to GT Interactive. They only delivered 2, but then demanded the guaranteed payment that was specifically allocated to those 2 delivered games. All right, let's analyze Scavenger to see how the court handled this. First, what were the legally dispositive facts? What really mattered to the judge?
The key facts were all right there in the contract itself. Scavenger was on the hook for 4 games, and the agreement laid out separate production schedules and separate payment schedules for each of the 4 games. So when Scavenger didn't deliver the last 2, they sued for the payment that was tied only to the first 2, which was a lot of money, over $2.4 million.
And what was the core legal issue, the main sticking point the court had to resolve first?
The issue was whether Scavenger's failure to deliver those last 2 games destroyed their right to get paid for the 2 they did deliver. And that question depended entirely on whether the agreement was one single entire contract or if it was a divisible one.
What was the precise rule of law the court applied, and how did they break it down for their analysis?
They applied the standard divisibility rule. The black-letter rule is that a contract is divisible if and only if it provides for separate performance and separate payment that corresponds to that performance. The single essential element they were looking for was the separation and apportionment of performance and consideration. That's it.
Thank you. Now for the court's element analysis. How did the court apply that single element of separation and apportionment to the facts in this case?
Well, they found the element was met, unequivocally. And they did it just by reading the contract. The contract literally contained separate production and payment schedules for each of the 4 CD-ROM games. Because the performance, delivering game 1, was financially matched to a specific payment. Distinct, economically severable deals all bundled together. The parties basically built a structural firewall between the parts.
And after analyzing that element, what was the court's final conclusion regarding divisibility?
The court concluded the contract was divisible. Simple as that. Therefore, Scavenger's partial breach failing on games 3 and 4, it didn't negate their right to recover the guaranteed money for games 1 and 2. The firewall held up. The breach was contained to the part that failed.
That makes a lot of sense, from a business perspective. You pay per unit, you should only lose money for the units you don't get. But this is where it gets really interesting. Even with the divisibility ruling, GT Interactive still argued that Scavenger breached the agreement by failing to deliver those first 2 games on time. So why couldn't GT hold them liable for that? What actions caused GT Interactive to waive this entire defense?
Right. And GT made a legal mistake you see all the time in these disputes. They forfeited their right to use that defense. See, a breach defense can be waived. It happens when the non-breaching party, knowing a breach occurred, then does something that's totally inconsistent with their right to complain about it later. The court in Scavenger used a 2-pronged test for this conduct. First, did they request significant modifications after the breach? And second, did they accept and market the goods without objection?
Okay, let's turn to this issue of waiver. What was the core legal issue around GT Interactive's ability to even claim a breach defense?
The issue was whether GT's claim that Scavenger breached by missing the deadline had been legally waived by GT's own commercial actions after the fact. Basically, did they forfeit their defense?
And what rule of law did the court apply here to figure out if there was a waiver? Can you detail those two elements they looked for?
The rule is that a breach is waived by conduct that affirms the contract, even though you know about the breach. The court looked for two specific elements of that conduct. First, did the non-breaching party ask for significant modifications to the items that were delivered? And second, did that same party then accept and market the items without objection?
Wait, that seems a little harsh. So you're saying if GT got the games late and instead of complaining, they just asked for a few bug fixes, that one act could just wipe out their whole defense? Let's analyze that first element, requests for significant modifications.
That's exactly right. And that's the policy behind the rule. The court found this element was met because GT Interactive did, in fact, request significant modifications in the games after the delivery date had already passed. By making scavengers keep working on the games, fixing bugs, improving things, they were essentially sending a message. They were saying, we're not happy you're late, but we still want this finished product under our contract. That kind of behavior affirms the contract. It completely contradicts any claim that the breach was bad enough to terminate the deal.
Understood. So that first element is all about confirming the ongoing relationship. Now, what about the second element? Acceptance and marketing without objection. How did GT's business activities end up hurting their legal case?
This element really sealed their fate. GT took the two late games and just went ahead and commercially accepted and marketed them without objection. In contract law, when you take a late or defective product and use it for your own commercial gain, you advertise it, you sell it, you are signaling very clearly that you accept that performance. They could have rejected the late delivery, but by marketing the games, they waived their right to later say the delivery schedule was a fatal breach.
So after looking at both the modifications they requested and their commercial activities, what was the court's final conclusion on the waiver issue?
The court concluded, as a matter of law, that GT's defense based on late delivery was completely waived, gone. And when you combine that with the divisibility ruling, it meant Scavenger was absolutely entitled to that $2.4 million for the games they finished. GT Interactive just lost all its leverage because its actions spoke louder than any complaint they might have had.
Okay, let's lock in this idea of divisibility with a visceral hypothetical. Imagine you own a high-end catering business. You sign a contract for a huge wedding dessert display. It has 12 elaborate custom tiers, and the contract specifically lists the price for each of the 12 tiers separately. You deliver 10 perfect, beautiful tiers, but the last two are, I don't know, destroyed when a fridge malfunctions on the way to the venue. How does the divisibility rule apply there?
Applying the rules strictly. Since the contract explicitly allocated a price, the consideration to each individual tier, the performance, the failure to perform on those two destroyed tiers is a breach of only that divisible part of the contract. The catering business still gets paid for the 10 perfect tiers they delivered. Why? Because the parties structured the deal to make each tier its own separate performance unit. Now, if the contract just said $10,000 for the entire dessert display, that's an entire contract, and destroying two tiers might have been a total breach, potentially putting the entire payment at risk.
So the lesson is crystal clear. The structure of your payment schedule is your main defense mechanism.
Exactly. And to make sure you can use this knowledge quickly on an exam or in practice, you need a diagnostic checklist. When performance isn't perfect, you have to follow these 3 steps in order. First, identify the breach. Figure out exactly what failed. Was it a late delivery? Or is it non-delivery of a specific unit? Second, determine divisibility. You have to ask, did the contract have separate schedules for performance and a corresponding payment for both the part that was breached and the part that was completed? That's the key structural question. If the answer is yes, the contract is divisible. The remedy is restricted just to the part that failed. And third, check for waiver. Did the non-breaching party, after they knew about the breach, take actions that were inconsistent with claiming that breach? Specifically, did they ask for significant modifications, or did they accept and market the goods without objection? If yes, the defense is waived, gone.
So the big takeaway from this deep dive is really that the architecture of the agreement, the financial breakdown, the timing details, that's what determines the remedy. You could lose your right to sue just by sending a simple email asking for a bug fix if you send it at the wrong time. So here's something for you to mull over. What if, GT Interactive had accepted the two games and marketed them, but immediately sent a formal written letter to Scavenger explicitly reserving all their rights to sue for breach because of the late delivery. Would the court still have found a waiver? Can you protect yourself from the waiver trap just by saying you're reserving your rights, or does commercial acceptance always override legal intent? That's the next level of exploration.